one of the proud promises of the civilized world has always been law, order, peace, and discipline, have long formed the basis on which countries were classified as first world or third world.
People in the West are a little bit tired from the decades of peace, democracy, wealth, and freedom. It is for themselves a little bit boring.
Administrative justice in Ukraine is a sphere in which the resilience of the rule of law is tested on a daily basis.
The Supreme Court of Sri Lanka found the former executive of this country liable for breach of constitutional duties. Rule of law has been advanced in its full plenitude in Sri Lanka.
Even the highest office be subjected to constitutional scrutiny.
We are judges, we are not political actors, and our duty is to protect the rights and the law under the Constitution.
Across Europe and indeed globally, narratives questioning the legitimacy of courts have intensified. The chilling effect of this type of action against the judges is a red line not to be crossed.
In Hungary, judges are not allowed to express political views.
Why is defiance of the rule of law gaining political appeal across the world?
Rest assured that the judiciary holds the final move.
We can uphold the rule of law only to a limited extent by our judgments and opinions, but we do not have means to enforce them.
Politicians must not interfere with the substance of judicial decision, but the organization and financing of the courts is a democratic issue too.
For one, never ever give up.
We simply need an openness to listen.
Thanks to Global South Network, which allow us to believe in a better world of the rule of law.
It's a wonderful initiative.
The Global South Network opened new horizons for judicial cooperations.
Global South Network provide a platform for meaningful dialogue and cooperation, fostering efforts to build a more equitable and resilient legal landscape.
GSN Network continues to expand areas of activity, further strengthening its impact and reach.
The universal concept of justice compels us to join our efforts, and this is the forum for promoting the same goal.
Well deserved for the hectic activity you have made. I am astonished, I am amazed, I was impressed.
May I at the outset commend you, Dr. Reayat, for the immense work that you're doing in the GSN. The Global South Network is a much admired initiative.
It's commendable. South Network focuses on all disciplines and regions, creating a bridge between academia, civil society, legal community, etc.
Nauman, thank you for all too kind introduction and your kind words. And ladies and gentlemen, to start with, I will express my deep gratitude to Dr. Nauman Reayat, who is founder and chief convener of the Global South Network, for creating a platform that does not simply celebrate consensus, but actively invites challenge, disagreement, and critical reflection. By bringing together judges, scholars, and practitioners from across the world, the network confronts how differently the rule of law is understood, applied, and at times undermined. I would also like to thank all the distinguished colleagues from several continents who have graciously agreed to participate in today's judicial dialogue. Your presence, insights, and commitment to the rule of law enrich this discussion immensely. This gathering would not be possible without your dedication, and we are deeply grateful for the time and expertise you bring to this conversation. It's a real privilege to speak in today's event, not to rehearse familiar narratives, but to question assumptions and engage with colleagues on a global issue that is anything but settled, whether the rule of law remains a lived reality or is increasingly becoming a rhetorical promise. I feel honored to share these reflections with you, but I do so with a deep sense of unease. The subject that brings us together today, the backsliding of the rule of law, is not an abstract concern of an academic trend. It is lived and accelerating reality, and one that should trouble judges worldwide. My concern is firmly grounded in recent global developments. Some of those were already mentioned by Dr. Reayat's introductory words. The World Justice Project Rule of Law Index 2025 reveals a stark picture. Nearly 68% of countries worldwide have experienced a decline in rule of law scores, with particularly serious erosion in constraints on government power and the protection of fundamental rights. This is not a problem confined to fragile states or emerging democracies. It is increasingly visible within established legal systems, including in Europe. Let me share some recent pieces of news from international media. From December 2025, mass protests in Bucharest, Romania, called for the resignation of senior judicial officials and sweeping reforms to safeguard judicial independence, following revelations of corruption at the highest levels of the justice system. In Hungary, critics argue that a decree issued on February 2026 ordering courts to drop ongoing cases against the government, including challenges to a controversial tax, has effectively overridden judicial authority and struck at the heart of judicial independence. Over the past year, several judges of the Supreme Court of Pakistan and the provincial high courts have either resigned or formally expressed concerns to the Chief Justice regarding the rule of law and judicial independence. Across the Atlantic, judges in the United States, whose jurisprudence has long shaped the global understanding of the rule of law, have faced threats of impeachment from the executive in direct retaliation for independent judicial decisions. These are only a few examples. Almost every country today confronts its own version of this crisis. Whether democratic or authoritarian, European or non-European, north or south, east or west, the erosion of the rule of law has become a truly global phenomenon. This compels us to ask uncomfortable but unavoidable questions. Why is defiance of the rule of law gaining political appeal across the world? Why is the rules-based international order under such sustained and coordinated attack? And most importantly, what can we as individual judges realistically do to resist this tide? The forces and issues judges confront are sometimes political, popular, and deeply polarizing. These conflicts inevitably arrive in our courtrooms, and when they do, the world is watching. Yet we are expected to remain apolitical, to stand firm when institutions tremble, to speak through reason when power shouts, and to defend principles that may no longer be fashionable. The question then is no longer whether the rule of law is under threat, but whether we are prepared to meet the threat with courage, restraint, and resolve. Paradoxically, it is institutions themselves that both protect judges from politics and expose them to it. Where institutions are clearly defined and robust, they shield judges from political entanglement. Where they are vague, incomplete, or unwritten, they demand a purposive judicial approach, one that may invite accusations of judicial activism or political interference. In either case, our judgments inevitably produce winners and losers, and criticism is unavoidable. There is no neutral refuge. It is institutions, written or unwritten, that shape shared values and determine how societies confront their most profound challenges. Allow me to begin with a discussion of institutions in the European context, which I am most familiar. The value foundation of the European Union is expressly articulated in Article 2 of the Treaty of European Union, which affirms respect for human dignity, freedom, democracy, equality, the rule of law, and human rights, including the rights of minorities. These values presuppose a society marked by pluralism, tolerance, justice, solidarity, and equality. They are not aspirational slogans. They are binding constitutional commitments. The so-called Copenhagen criteria further reinforce this foundation. They require not only democratic institutions, respect for human rights, and a functioning market economy at the moment of accession, but, according to the settled case law of the Court of Justice of the European Union, their continuous observance throughout membership. This means that every member state has freely accepted the principle of liberal democracy, the rule of law, and human rights as permanent obligations. Against this backdrop, the notion of so-called illiberal democracy advanced by Prime Minister Viktor Orban is a contradiction in terms, one that is fundamentally incompatible with membership in the European Union. Although the rule of law is not exhaustively defined in the EU treaties, it is clearly presupposed. Among the most influential articulations is the Venice Commission's Rule of Law checklist, updated in December 2025. At its core lies a simple but demanding insight. Democracy, the rule of law, and human rights are mutually reinforcing. Without an independent judiciary, individuals lack effective remedies. Without effective remedies, rights become illusory. And where courts can be silenced or subordinated, executive power becomes unchecked. But courts do not operate in vacuum. Their independence can only function meaningfully within a broader ecosystem of accountability, one that depends on transparency, public scrutiny, and informed citizens. The rule of law is therefore not sustained by judges alone, but by a wider constitutional culture that insists that power must always justify itself. This is why the principle that no one should be above the law is inseparable from the existence of independent and pluralistic media. Accountability must apply to all, especially those who govern, and without reliable information, the public cannot hold power to account. In an era of disinformation, cyber manipulation, and hate-driven narratives, free, independent, and responsible media are indispensable to democratic choice. Where citizens are uninformed, elections lose their meaning. Where scrutiny weakens, power hardens, and history shows that when scrutiny fades, the judiciary is often the next institution to come under pressure. The warning signs are no longer theoretical. Across Europe and beyond, courts have been targeted through court packing, forced retirements, disciplinary chambers, punitive transfers, and restrictions on judicial dialogue with supranational courts. The European Court of Human Rights has condemned blatant violations of judicial appointment procedures, including a Grand Chamber judgment against Iceland, where merit-based selection was openly disregarded. History reminds us that these tactics of court packing are not new. Even Franklin D. Roosevelt famously threatened to expand the US Supreme Court to secure political approval for the New Deal. But long before that, as Emma Southon recounts, the Roman king Tarquinius doubled the Senate with loyalists to entrench his power. Vestigia terrent, the footprints warn us. What these examples show is that the erosion of the rule of law rarely begins with tanks or coups. It begins with technical adjustments, procedural shortcuts, and narratives of efficiency or popular will. And it often ends with judges standing alone, asked to uphold principles precisely when doing so is most costly. That is the moment we must be prepared for, because if judges retreat when pressure mounts, the rule of law does not merely weaken, it collapses quietly from within. And this danger is not confined to fragile systems. It can unfold just as easily in long-established democracies as in openly authoritarian regimes. It is precisely for this reason that developments in the United States deserve close and sober attention. For decades, the United States has been seen as a lighthouse of democracy, constitutional freedoms, equal opportunity, and judicial independence. Its courts have long set global benchmarks, shaping how the rule of law is understood far beyond its borders. Yet today, even lighthouses can flicker. Recent developments during Donald Trump's second term have raised serious questions about the resilience of American democracy and the rule of law. I will confine myself to a single source, an editorial opinion published by the New York Times on 1st November 2025 entitled, "In Trump's America, Are We Losing Our Democracy?" I'm of course fully aware that the New York Times is ideologically extremely distant from MAGA Republican thinking. That, however, does not relieve us of the responsibility to engage seriously with the arguments presented. The editorial board identified 12 markers of democratic erosion. They did not claim that the United States has become an autocracy akin to Russia or China, but they warned, crucially, of a slide towards authoritarianism. Among the indicators they listed were the suppression of dissent, persecution of political opponents, bypassing of the legislature, defiance of courts, misuse of emergency powers, vilification of minorities, control of information, pressure on universities, cultivation of a cult of personality, personal enrichment through power, and manipulation of law to retain office. These indicators are not abstract warning signs. They require meaning only when we ask how far they translate into practice and whether existing constitutional safeguards are strong enough to resist them. Time does not permit a detailed discussion of examples, but none of us who follow the news seriously can pretend ignorance. What remains uncertain is whether the American system of checks and balances will ultimately prevail. The president has not so far openly defied rulings of the Supreme Court. Yet recent scholarship, including work of German constitutional scholars, suggests that observance of a conservative majority court may, in sensitive cases, show increasing deference in interpretations aligned with executive agenda. That alone should give us pause. But the very recent Supreme Court judgment on tariff provides hope for the future. At this point, a clarification is essential. Neither United States nor the European Union member states previously discussed, such as Hungary and Poland, are dictatorships. No. They hold elections. Opposition parties exist. Political competition is not abolished. But, as said, democracy does not collapse overnight. It erodes incrementally through gerrymandering, media pressure, selective party financing, and the instrumentalization of law. Elections may remain, while their fairness is quietly hollowed out. Why, then, focus so intently on the United States? Not only because it remains the world's sole superpower led by the most powerful individual on the planet. What matters just as much are its evolving security and foreign policy doctrines, and, in particular, how Europe is perceived within them. The current US administration has openly criticized the European Union for liberalism, migration policies, climate action, and minority rights. It has also explicitly supported European governments and movements that share its worldview. These positions do not remain confined to rhetoric or diplomacy. In an interconnected political environment, they travel quickly across borders and translate into influence on domestic debates within Europe itself. These consequences are tangible. Political parties and movements in Europe now receive ideological and sometimes material support from overseas for agendas that sit uneasily with EU values and member state commitments referred to earlier. The old Cold War divide between capitalism and communism has faded. The new fault line is different. One influential framing is the so-called GALTAN divide, meaning green, alternative, liberal versus traditional authoritarian nationalist. This is not merely a cultural clash, it is a constitutional one. Seen through this lens, the rise of autocratic national conservative movements becomes easier to understand. Often described as populist, their defining feature is a direct appeal to the people, coupled with deep suspicion toward institutions, especially courts. They reject a core premise of the rule of law. Democracy is not a dictatorship of the majority. Human rights do not depend on opinion polls. It is precisely at this point where majority will collide with constitutional limits that independent courts become both indispensable and acutely vulnerable. This vulnerability is further intensified by political polarization. Even societies with strong liberal traditions struggle with political discourse shifts toward extremes. The challenge is real. How do we defend liberal democratic values, those embedded, for instance, in Article 2 TEU, without drifting so far into abstraction that they lose the confidence of the majority? This tension is not hypothetical. It defines our moment. And it is because this struggle is so widespread and unresolved that its consequences are now visible far beyond any single country or region. Globally, the rule of law is not merely backsliding, it is in danger of free fall. As mentioned at the outset, rule of law scores have declined in most countries for at least 7 consecutive years. According to the Finnish Rule of Law Center, more than 5.7 billion people now live under autocratic regimes, and 1.5 billion lack meaningful access to justice. Rising authoritarianism and weakening judicial independence are central drivers of this regression. These developments leave little room for complacency. The rule of law is under attack across the globe. In some countries, it has so far been successfully defended, but even there it remains vulnerable and fragile. The rule of law is not self-executing. It cannot be taken for granted. If it is to survive, it must be consciously protected and, when necessary, actively defended. What strikes me most is how frequently large segments of the population are drawn to authoritarian, nationalistic, and conservative currents, even when the empirical evidence speaks so clearly against them. This is all the more puzzling when we turn to decades of rigorous economic and institutional research demonstrating that societies governed by the rule of law consistently outperform those that are not. Countries that score highest on the rule of law indices, such as Denmark, Norway, and Finland, are also among the most prosperous, stable, and yes, happiest societies on earth. This is not coincidence. It is correlation with causation. The lesson is unmistakable. When the rule of law weakens, prosperity, trust, and freedom follow it down. However, I do not suggest that Finland is free from rule of law challenges. For example, court proceedings can be excessively lengthy, and the prevalence of domestic violence remains deeply concerning. There's always room for improvement. Societies marked by weak institutions and extractive governments do not generate sustainable growth or genuine social progress. This insight has been powerfully articulated by the 2024 Nobel Prize laureates in economics, Darren Acemoglu and James A. Robinson. In Why Nations Fail, published in 2012, and The Narrow Corridor, 2019, they show through history, data, and comparative analysis that prosperity flows from inclusive institutions built on trust, accountability, and the rule of law. Where institutions are extractive, designed to benefit those in power, societies become trapped in stagnation. And yet, despite this knowledge, the global trajectory is moving in the opposite direction. Authoritarianism, nationalism, and populism are on the rise. Institutions are openly despised. The naked exercise of power is admired. A rules-based international order is increasingly replaced by a deals-based one. Minorities and women are exposed to hostility rather than protection. This forces us to ask uncomfortable question. Is the liberal rule of law based vision of democratic society merely under strain, or is it at risk of being abandoned altogether? If this diagnosis is correct, the next question becomes unavoidable. How can the rule of law be secured for the future, and what concretely can judges and court presidents do? History offers a stark answer. One of the most reliable routes to authoritarian consolidation is the capture of apex courts and independent media. Once constitutional courts and free press fall under executive control, effective checks and balances disappear. This strategy is no longer theoretical. Its footprints are visible in multiple jurisdictions. Yet this is not the only path available. Some countries have chosen a different path, acting before the fire starts. In several Nordic states, including Norway, Sweden, and now also Finland, we are following a path to strengthen the constitutional guarantees for independence of courts, for instance. Of course, the most fundamental defense of the rule of law remains everyday judging. Integrity, impartiality, transparency, careful reasoning, timely justice. Courts defend the rule of law not through rhetoric, but through the quiet discipline of principled decision-making day after day. Yet new and troubling threats are emerging. The United States has imposed sanctions on judges and prosecutors of the International Criminal Court for carrying out their statutory duties. These individuals were effectively cut off from banking and essential services linked to US-based companies. European judicial associations rightly condemned this as an extreme form of pressure on an independent court. But the chilling effect may go further. Can we be certain that national or European judges will feel free to decide cases impartially when powerful foreign interests are involved? This is not a marginal issue. It strikes the very heart of judicial independence. In the European Union, unity in defense of shared values is not optional. It's a constitutional necessity. In a turbulent world, adherence to the rule of law is not only a legal obligation, it's also the most reliable path to prosperity, trust, and social cohesion. If proof is needed, we need only look at Estonia. In a little more than 3 decades since regaining independence, it has risen into a top tier of global rule of law rankings. Estonia's success demonstrates that even against daunting historical odds, a deliberate commitment to institutions, trusts, and legality can deliver remarkable results. That is the hopeful note on which I would like to end. The rule of law is fragile, but it's also powerful. And when defended with foresight, courage, and integrity, it remains one of the humanity's most successful inventions. And it's precisely because the rule of law is both fragile and powerful, platforms for dialogue, reflection, and mutual learning matter more than ever. And this is why this platform, governed by Dr. Reayat, is so very precious at this very moment. And for this vision and for the tireless effort required to turn it into reality, my sincere thanks go to Dr. Nauman Reayat. His commitment to fostering genuine exchange among judges, scholars, practitioners, and societal actors has created not just a network, but a community. I look very much forward to hearing the responses of my esteemed colleagues from across the world. Thank you.